Hi, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to talk about the lawsuit process. How does everything work in a personal injury case? So a lot of people want to know, how long is my case going to take? How much am I going to get, and how long is it going to take? So this video will be more about the question of how long and talking about the entire process. So usually in the beginning, depending on the type of case you have, the lawyer will conduct an investigation while the client will get much needed medical care if there's a serious injury. And you don't want to settle the case at this point, because if you settle the case early, which you can do, we've settled cases even as quickly as 3 to 4 months from the date of the incident. But if you do that, you want to make sure that there's no serious injury and that the client does not want any more medical care, like they're completely fine, they've been checked out, they've been vetted, and there's no reason to get any more care. Because what you don't want to have happen is you settle the case quickly, like in 4 or 6 months, but then later on the client is told, well, you're going to need a surgery or you're going to need more treatment, because now no one's going to pay for that treatment, and also you're not going to be compensated for that injury. So you don't want to cut the case prematurely and settle it too quickly. But in this stage, the important thing is for the client to make sure that they're going to doctors and going to the right doctor. So you want to be, depending on the type of case, if it's a car crash, let's say, depending on the injury that you have, you may be going to like a physical therapy office, and there they'll do MRIs to then diagnose what your injury is, like a C2, C3 herniated disc, for example, or an L5-S1 bulging disc. You may have clear-cut injuries, right, like a laceration or a broken bone. And then at that point, the most important thing you can do as a patient, as a client, is to get this medical care. Whereas what the lawyer can do is help coordinate the medical care. So make sure you're going to the right doctor. If the doctors, like the physical therapy, aren't really helping you because they're just doing like chiropractic adjustments and you have something much more serious, then the lawyer can help find the right specialist, like the neurologist or the orthopedic surgeon or whatever specialist you may need, so you're not just going getting like massages and it's not leading to anything, right? You want to stay on top of the case, stay on top of the client, and have that constant communication. The other important thing at this stage is for the attorney and the office to do a full investigation. So you go to the scene, you take photos, you interview witnesses. If it's a different kind of case, like a ceiling collapse, you might want to run reports on the building, see prior incidents, prior complaints. So you want to do a deep dive into the investigation. Then, after you're all done with your treatment, it really depends on how seriously you're injured. So, like I said before, if you're not that injured and it's all soft tissue and you're all done with your therapy, at that point the lawyer can then request all your medical records, send a settlement package to the adjuster, negotiate the case as a claim, and settle it. Usually that's going to be a smaller number, anywhere from like $5,000 maybe to $20,000, $30,000. It usually is not going to be a big number, but it's done fairly quickly. And the reason for that is because the injury is limited. You're not needing any more treatment. You're feeling fine. And so you want to resolve the case. Now, if it isn't more of a serious injury and you do end up needing something like a surgery or pain management injections or something more serious like a traumatic brain injury, then what you would do is you file a lawsuit. And then at the lawsuit stage, you file it in the Supreme Court, you serve it on the defendants, they then appear in the case, and then you have a preliminary conference before the judge. And that all just takes a few months at most, like filing a lawsuit, serving it, waiting about 30 days, having them appear and answer, filing an RJI, a request for judicial intervention, to then get a judge, and then getting a preliminary conference set up a few months later. At the conference, they'll set deposition deadlines, exchange of documents, and then once that's done and all discovery is done, you can then certify the case as trial ready by filing what's known as a note of issue, putting it on the trial calendar, and that'll trigger like mediations, settlement conferences, and then finally, if it still doesn't settle, a trial date. But at this point, everyone already knows, right, because they've done a deposition where they interview you and they ask you all the questions about liability, how it happened, your injury, the impact this has had on your life. They have all your medical records, so at this point they know everything. So they're more likely to then be able to offer you a fair settlement. And also, depending on how you litigate the case, if you litigate it aggressively and say, look, I believe this is a big value case, I have all the proof, I have all the evidence, then you want to show the insurance company why they should be paying you your number as opposed to lowballing you. So that's basically how it works. Now, the place where the cases sometimes get stuck is probably in discovery, right? Because discovery is a very vast and big open topic. So what can happen is a plaintiff's attorney might send a notice for discovery and inspection wanting to get some meaningful responses, whereas the defense lawyer will just say, you know what, objection, objection. And then if the plaintiff's attorney doesn't do anything, or if they file a motion, they might wait months and months for the judge to decide the motion. And then if the decision isn't strong enough, they might not be able to get what they need to prove the case. And in the same way, if the defense attorney is just producing a witness, what if they produce a witness that doesn't really know enough? Then you need a second witness, a third witness. And this is where discovery could really get extended. The other way it can get extended is if the plaintiff gets deposed, but then after the deposition goes and does like another surgery. Well, now the defendant will want another deposition for this new surgery. And they'll want maybe the medical records from this new doctor that they don't know about yet, right? So that delays. Now you have a second plaintiff deposition. Now that you have to get them authorizations for this new doctor, obtain the medical records. So that could delay the case. But usually the courts, depending on the court, they have like strict timelines, and then they'll keep a little bit of order depending on which court you're in. Sometimes in state court it's a little slower depending on the county. Federal court is much quicker. But they'll keep some order and they'll keep tabs on depositions. And then once everything is done, you certify the case as trial ready. You're on the trial calendar, and the wait for a trial date is probably close to a year. Maybe in some counties even more than a year. And then once you have the trial, that's when you'll pick the jury, do your opening statement, put on witnesses, do your closing argument, and then have the verdict. And by then, you'll also need to do, of course, trial prep, like obtaining the subpoenas of all the records to come to a courthouse and things like that. But usually most cases don't go all the way to trial. Most cases settle. So there's a good chance that your case may settle somewhere along the timeline. I feel like the important thing to do as an attorney is to do a real proper investigation, because that becomes like the foundation for your case, and be a gatekeeper at the complaint stage. Don't just go filing lawsuits like willy-nilly. Make sure that you really have all your evidence as to liability, as to damages. Think about your experts early. So when you're filing a lawsuit, you already have your experts, you have your medical records, you have your proof of liability, and that way you can move through the lawsuit process faster. So that's an important foundational step. Like, you want to build a strong foundation. Just like if you're building a house, you want to have a strong foundation. And then at trial, you want to be really ready, because the more ready you are for trial, the more likely that you won't go to trial, because the defendants will see that you're ready and they'll pay you a fair settlement. So I hope this was helpful. Let us know what questions you have about the lawsuit process. We are here for you. Our goal is helping serious injury victims and their families. All the best. Okay, bye-bye.